If you've been nominated as an executor under a will, then you should be mindful that certain people can apply to the court after the will maker dies for orders which result in them receiving more from the estate than the will allows for. I'm John Gallagher from Argon Law, and I'd like to tell you how executors are affected by these applications, known as family provision applications. So keep watching. Spouses, children, and certain dependents of the deceased can bring these applications if they've been left out of the will altogether, or even if they believe that what the will provides for them isn't adequate. What they need to prove is that the will fails to make adequate provision for their proper maintenance and support. What is adequate or proper will depend on the facts of each case. But as an executor, it's important for you to understand that there are certain time limits within which these applications must be made. You should be very reluctant to allow any distributions of assets from the estate before you are confident that the time for an application to be made has passed. This point is very important because if a successful application is brought after you make distributions, you could find yourself personally responsible to pay the money back to the estate. If an application is made, then as executor, your primary duty is to defend the claim and uphold the wishes of the deceased. However, where appropriate, you may need to negotiate a compromise that satisfies the various parties. An executor must notify all interested parties that a family provision application has been made, participate in settlement and mediation discussions, and present to the court all relevant evidence. If you'd like to know more about family provision applications, or deceased estates in general, don't hesitate to give us a call at Argon Law. And if you found this video useful, then please comment below and have a look at our website.